ripple echo.
And we all have this feeling that I came into this world. Now, it isn't true. You came out of this world.
Series 1, Episode 6. In 2024, the Supreme Court rewrote the ground rules. With the fall of Chevron deference, federal judges are no longer bound to respect how agencies interpret the laws they enforce. The result? A judiciary with more power and an executive branch forced to tread more carefully. This wasn't a policy shift. It was a constitutional realignment. Quiet, technical, and transformative.
Imagine for a moment that the complex world of global trade, which affects, everything from the price of goods on store shelves to jobs in your local industry, isn't just being shaped in negotiation rooms or presidential offices. Instead, picture it unfolding within the quiet, deliberate confines of courthouses.
Hey.
That's right. Judges in black robes are increasingly picking up the compass and ruler, sort of helping to redraw the map of who gets to decide America's trade policy.
That's the truly fascinating scenario. Over the past 5 years, roughly from 2019 through early 2025, we've witnessed a really significant shift.
The big shift.
Yeah. Federal courts at different levels have stepped onto the stage as crucial arbiters, defining the boundaries of power between Congress and the president, specifically when it comes to setting trade policy.
And this isn't just about debating the wisdom of a specific tariff or regulation. What we're exploring today has deep legal and constitutional weight. It's about fundamental questions of authority, about how judges are, in a very real sense, rewriting trade power with their gavels.
Courtrooms, perhaps surprisingly, have become new fronts in the ongoing trade battles.
And our guide for this is the stack of source material you, our listener, shared with us. You wanted to understand this intricate intersection of law and commerce, and these documents, well, they provide a compelling look.
So we'll explore what amounts to a seismic shift in how courts review the actions of government agencies.
Exactly, and shine a light on the role of specific legal challengers who are actively pushing these boundaries in court.
So, get ready. We're going deep into the legal thinking, the court's view of these trade powers, and the broader economic and political ripples these decisions are causing.
Okay.
Let's start by setting the stage, the judicial stage itself, and understand how exactly U.S. courts found themselves so deeply involved in the trade game in the first place.
While we often hear the headlines about executive orders on tariffs or congressional bills, the courts have always had a crucial, albeit often less visible, oversight role in this whole system.
Their job is to review whether executive actions, like imposing a tariff, actually line up with the statutes, the laws that Congress has passed, and perhaps most fundamentally, whether they're consistent with the Constitution itself.
So they're like the referees, making sure everyone is playing by the rules that Congress wrote and the Constitution set.
Exactly. And there's a specific structure to this. If you're challenging a tariff or a trade measure, you often start at a specialized court called the U.S. Court of International Trade, the CIT.
The CIT?
Think of it as the initial legal battleground, designed specifically for these kinds of disputes.
And if a company or individual doesn't like the CIT's decision, what happens then?
Then they can appeal it. Those decisions go up to the U.S. Court of Appeals for the Federal Circuit. This appellate court frequently has the final say on many trade-related legal matters.
Tug?
And occasionally, though less often, a case is significant enough that it might reach the Supreme Court, which either weighs indirectly or, by choosing not to hear it, effectively lets the lower court rulings stand.
Okay, so the courts are structured to review trade actions. But what's the main source of conflict they've been grappling with recently? What's the big tension?
The core tension, and really the heart of many of these recent cases, is the balance of power between Congress and the president.
Okay.
See, the Constitution in Article 1 explicitly gives Congress the power over tariffs and foreign commerce. That's fundamentally a legislative power.
Right.
But Congress has also passed laws over the years that delegate some authority to the president to act on trade matters under specific circumstances.
And I'm guessing when presidents take really strong action, citing those delegated powers, that's where the judges have to step in and interpret the limits. Is that where it gets tricky?
Precisely. When the executive branch, especially over the past few years, has taken aggressive trade measures, often using broad justifications like national security or unfair foreign practices, it's forced judges to look closely at those statutes and decide, Did Congress really give the president the authority to do that? Have they overstepped the bounds of the laws Congress wrote?
And that interpretive role has made the judges, these key arbiters we mentioned, they're the ones deciding the boundaries.
Yes, they're the ones deciding if the president's actions fit within the scope of the laws Congress created. Sometimes the courts have said, yes, Congress gave the president a lot of flexibility here, essentially upholding broad executive latitude.
Okay.
But in other significant instances, they've drawn the line and curbed actions they found went too far, either beyond the statutory grant or, in violation of the Constitution.
What about international trade rulings, say from the World Trade Organization, the WTO? How do U.S. judges handle those if a domestic trade action is challenged in court? Does that come up?
This is a critical point to understand, yeah. U.S. judges consistently affirm that U.S. domestic statutes prevail over international trade rulings. A WTO ruling against a U.S. trade measure does not automatically make that U.S. measure illegal in a U.S. court.
So even if the WTO says, hey, that U.S. tariff violates international rules, a U.S. court isn't required to strike down the tariff based purely on that.
That's absolutely correct. Under U.S. law, like the Uruguay Round Agreements Act, WTO rulings have no automatic legal effect within the U.S. legal system, unless Congress or the relevant U.S. authorities specifically choose to implement those global decisions into U.S. law.
I see.
Private parties challenging a U.S. measure in court cannot succeed simply by citing an unfavorable WTO outcome. The focus for the U.S. court remains on whether the action complies with U.S. statutes and the U.S. Constitution.
Okay, let's take a moment here, maybe a quick micro recap just to make sure we've got this foundational piece locked in.
Good idea.
The basic idea is that U.S. courts have this oversight role in trade policy, checking executive actions against the laws Congress passed and the Constitution.
Right.
The core tension they're refereeing is this balance between Congress's original authority and the president's actions under delegated power.
Delegation, yeah.
And importantly, U.S. courts operate under U.S. law, meaning international rulings don't automatically override domestic trade measures.
That's a solid recap. It's a system where U.S. domestic law is supreme, with courts acting as the crucial checks on the executive's use of authority granted by Congress.
So as you think about this basic setup, this push and pull between the branches and the court's role, which part of this power dynamic feels most significant to you? Is it the initial grant of power from Congress, the executive's actions, or the judiciary's complex job of interpreting the limits?
Well, for me, it's definitely that interpretation part, especially when the executive is really pushing the boundaries.
Yeah, me too. Which leads us nicely into our first major battleground. Tariffs levied under the gavel, particularly those citing national security and those imposed during the recent trade wars.
This is where the courts really started getting tested. One of the first big flashpoints came in 2018, when President Trump imposed significant tariffs on steel and aluminum imports.
Okay.
These weren't based on traditional unfair trade findings. They were levied under Section 232 of the Trade Expansion Act of 1962, a statute that allows the president to restrict imports if they are found to threaten national security.
And importers quickly challenged these, right? Arguing the very law itself was unconstitutional.
Exactly. They took the government to the Court of International Trade, arguing that Section 232 gave the president too much power and unconstitutional delegation of Congress's exclusive authority over trade. This became the case of American Institute for International Steel v. United States, AIIS.
How did the court respond to that core constitutional challenge? That seems huge.
In 2019, a three-judge panel at the CIT upheld the constitutionality of Section 232. They acknowledged it grants the president significant discretion. However, they pointed to a 1976 Supreme Court precedent, the Algonquin case,
Algonquin, okay.
which found that Section 232 did contain an intelligible principle guiding the president's action. That principle, the requirement that the president must determine if the imports actually constitute a threat to national security.
So the court's view was Congress gave power, yes, but they also set a clear test, find a national security threat, and that test is enough of a guide to pass constitutional muster. Is that basically it?
That's the essence of it. It's worth noting a subtle point here, though. One of the judges, Judge Katzmann, wrote a separate opinion where he concurred dubitante.
Dubitante? What does that mean?
It means concurring with doubt. He suggested that while he felt bound by Supreme Court precedent, Section 232 might indeed be pushing the very limits of how much power Congress can hand over to the executive.
Wow.
But he felt only the Supreme Court could ultimately revisit that established precedent.
And what happened when the case went up on appeal? Did the Federal Circuit agree with that doubt?
In 2020, the Federal Circuit, the appellate court, affirmed the CIT's ruling. They also found Section 232 was a permissible delegation, relying on Supreme Court precedent.
Got it.
When the case eventually reached the Supreme Court, they declined to hear it later in 2020.
So by choosing not to hear the case, the Supreme Court effectively left those national security tariffs in place and, by extension, seemed to endorse the lower court's approach of deferring to the executive on the constitutionality of the law itself.
That's a critical point, yeah. This sequence of decisions underscored the judiciary's reluctance to disturb Congress's broad grant of trade power to the executive, especially when existing Supreme Court precedent was in play.
And the practical effect was?
Huge. The court actions allowed the U.S. to maintain tariffs that prompted retaliation from trading partners and faced WTO challenges, fueling a significant part of the trade war. Legally, it signaled that Section 232, despite its broad grant of power, was on firm constitutional footing based on that intelligible principle.
Okay, so the core takeaway from the AIS case on Section 232 is that the courts upheld the constitutionality of Congress delegating this power to the president, finding the intelligible principle of determining a national security threat was a sufficient guide.
Right. Now, moving on, another related battle involving Section 232 tested a different boundary: the president's flexibility to adjust tariffs after they had already been imposed.
Adjust them. How?
Well, in August 2018, just months after the initial steel and aluminum tariffs, President Trump specifically doubled the steel tariff rate for imports from Turkey, citing a lack of progress on broader trade issues, while keeping the rate at 25% for other countries.
Okay, that sounds like it might have gone beyond the initial finding, singling out one country like that.
It did, and it led to the case of Trans-Pacific Steel LLC v. United States. Importers challenged this Turkey-specific increase at the CIT. Initially, a 3-judge panel there struck down that increased tariff in 2020.
Really? Why did the CIT say no to that specific change?
The CIT panel took a relatively strict reading of Section 232's process. They found that the president had missed the statutory deadlines for taking action after receiving a national security report. The law gives 90 days to decide and 15 days to implement.
Ah, the timing.
Yeah. The court held that the president couldn't simply modify the tariffs later, especially to make them more restrictive for a specific country, without starting a new investigation and adhering to new deadlines. They also argued that singling out Turkey for a higher rate without a new specific national security rationale tied to Turkey violated the Fifth Amendment's guarantee of equal protection. It's like the court told the president, you missed the train on making that specific change, and you can't just jump back on later without buying a new ticket, which means starting a new process.
So the CIT focused on strict procedural limits and fairness between countries. Makes sense.
Exactly. However, this ruling was reversed on appeal by the Federal Circuit in 2021. The appellate court sided with the government, adopting a much broader view of the president's authority under Section 232.
Oh, okay. How did the Federal Circuit interpret the law differently then?
The Federal Circuit reasoned that Section 232 allows the president to implement a continuing course of action. This means the initial decision isn't a one-time shot. It's the start of an ongoing plan of measures.
A continuing course.
Right. As long as the president took the initial action within the statutory time frame, they could adjust or tailor those measures over time, including increasing the rate for specific countries like Turkey if it helped achieve the overall objectives of the national security plan.
That's a much more flexible reading, giving the president a lot more room to maneuver.
It is. The Federal Circuit also applied a highly deferential legal standard called rational basis review to the Turkey tariff itself.
Rational basis.
Under this standard, the court only had to find a conceivable national security or diplomatic rationale for targeting Turkey. Since such a rationale could be imagined, the court found no equal protection violation.
So the Turkey tariff remained in effect, and the Federal Circuit's more flexible view prevailed.
Yes. This outcome strongly reaffirmed the executive branch's flexibility to tailor Section 232 measures in response to evolving circumstances, even if those circumstances are partly driven by foreign actions like counter tariffs.
And politically.
Politically, it preserved a significant tool for the executive to exert leverage in foreign relations. It also signaled to U.S. allies that relief from these national security tariffs would more likely come through diplomatic negotiations than through challenging the president's adjustments in court.
Got it.
And just like the AIS case, when the Supreme Court later had chances to review other Section 232 issues, they declined, indicating a high bar for judicial intervention in these matters.
Right. The key takeaway from Trans-Pacific Steel is that while the CIT initially sought to impose strict time and fairness limits on adjusting Section 232 tariffs, the Federal Circuit reversed, allowing broad executive flexibility to adjust these tariffs over time as part of a continuing course of action.
Let's pause here for a brief moment just to make sure we're keeping track of these Section 232 cases. What we've seen is that courts have upheld the basic constitutionality of giving the president this national security trade power. But they've definitely grappled with how that power is applied and when, especially concerning making changes.
Right. The CIT showed a willingness to enforce stricter procedural interpretations on timing and fairness, but the Federal Circuit ultimately adopted a broader view, emphasizing the executive's ability to modify measures as part of an ongoing plan. That difference between the trial court and the appellate court seems like a recurring theme.
It is, yeah. Okay, now let's shift gears to another massive set of trade war cases. The Section 301 tariffs imposed against China.
Yes, the China tariffs. Huge deal.
These tariffs began rolling out in 2018, imposed by the U.S. Trade Representative, or USTR. The initial basis was China's unfair trade practices, particularly those related to intellectual property and forced technology transfer.
Okay.
But as the trade dispute escalated and China retaliated, the USTR imposed later rounds of tariffs, often referred to as Lists 3 and 4A, covering hundreds of billions of dollars in Chinese goods. These later rounds were widely seen as a response to China's own counter tariffs.
And predictably, U.S. importers hit by these massive tariffs challenged them in court. It seems inevitable.
They did. Thousands of importers filed lawsuits, which were consolidated at the CIT under the heading in Section 301 cases. The importers argued that these later rounds, Lists 3 and 4A, exceeded the USTR's statutory authority under the Trade Act of 1974, and they also violated the Administrative Procedure Act, the APA, which governs how federal agencies make rules.
Okay, so the first big legal question for the CIT was, did the USTR actually have the statutory power under Section 301 to impose tariffs as retaliation for China's counter tariffs? Was that allowed?
In April 2022, the CIT ruled that the USTR did not overstep its statutory authority by expanding the tariffs to cover goods on Lists 3 and 4A.
They didn't overstep. Okay.
Right. The court examined Section 301, which includes language allowing the USTR to modify or terminate a previous action under the statute. The CIT interpreted this modify or terminate provision as being broad enough to cover increasing the tariffs on more goods in response to China's escalations.
What was the importer's argument against that? How did they read modify?
They argued that the power to modify should only allow changes to address an increased burden from China's original unfair practices, not to retaliate against China's response. They also brought in the Supreme Court's evolving major questions doctrine.
That again.
Yes, arguing that tariffs of such immense economic significance required much clearer, explicit congressional authorization than a general power to modify an action.
And the CIT wasn't convinced by that argument either.
No. The court found the Section 301 delegation was intentionally designed to be expansive, given the statute's goal of giving the executive tools to counteract foreign trade barriers. So the CIT upheld the legality of the China tariffs under U.S. law, confirming that the president, acting through the USTR, had wide latitude to respond in a trade dispute.
Okay, so the statutory authority for the tariffs themselves was upheld, but what about the procedural issues under the APA? You mentioned that.
This is where the CIT found a problem. The importers argued that the USTR had failed to adequately consider the public comments they received on the proposed Lists 3 and 4A tariffs.
Right, the comment period.
In a separate decision in 2022, the CIT agreed with the importers on this point. The court held that the APA's foreign affairs exemption did not excuse the USTR from its basic obligation to engage meaningfully with public input, even in the context of a trade war.
Interesting. So even though it was a high-stakes trade dispute, agencies still had to follow basic public comment rules. They couldn't just skip that.
That's right. The court emphasized that agencies must follow basic rulemaking procedures, including transparency and demonstrating reasoned decision-making based on the comments they receive. The judges found a procedural violation here, calling the USTR's lack of adequate response to comments an arbitrary and capricious lapse in the process.
Arbitrary and capricious.
Yeah.
Okay. But they didn't just wipe out the tariffs because of that procedural error. What was the remedy?
No, they didn't go that far. The court was likely aware of the enormous economic disruption and international fallout that would result from suddenly invalidating hundreds of billions of dollars in tariffs.
You'd think.
Instead, they ordered a less drastic remedy. They remanded the action back to the USTR, requiring the agency to go back and provide a better, more adequate justification for the tariffs in light of the public comments.
So it was a procedural fix, basically. Go back and show your work.
Exactly. The USTR subsequently complied, issuing a very lengthy explanation on remand. And in March 2023, the CIT issued its final decision, accepting the USTR's explanation and sustaining the lists 3 and 4A tariffs as properly justified.
Meaning those Section 301 China tariffs covering over $300 billion in trade remain in effect today.
Yes. Importers are still paying those duties, which are often passed on to consumers. This whole Section 301 litigation saga shows the court's balancing act. On one hand, affirming the executive's broad statutory power to act aggressively in trade disputes. On the other hand, upholding the importance of procedural safeguards and administrative law, even in a high-stakes trade war.
And this happened even though the WTO had found these tariffs violated international rules, didn't it?
That's another crucial piece. A WTO panel in 2020 did find the U.S. Section 301 tariffs were inconsistent with WTO rules. But because U.S. courts were upholding the tariffs under U.S. law, U.S. authorities kept them in place. The U.S. essentially used the domestic court's sanctioning of the tariffs as legal cover against international pressure from the WTO, pending a broader resolution.
And this case is still winding its way through the courts. It's not over.
Yes, the importers have appealed the CIT's final decision to the Federal Circuit. They are still arguing that the USTR exceeded its statutory authority under Section 301, pushing the major questions doctrine, and arguing the APA procedural lapse should have invalidated the tariffs entirely.
Okay.
The Federal Circuit's decision, expected sometime in 2024, could set further precedent on how much judges will rein in trade measures of this economic and international magnitude.
Right.
So the key takeaway from the Section 301 cases is that while courts upheld the USTR's broad statutory authority to impose these tariffs, they did require the agency to fulfill procedural obligations under the APA by adequately addressing public comments, although this lapse didn't invalidate the tariffs outright.
Okay, let's take a step back now and do a kind of mega recap for this whole chapter on the tariff wars in court. We've covered the Section 232 cases involving national security tariffs and the Section 301 cases regarding the China trade war. What overall pattern do we see in how the courts approach these aggressive tariff actions by the executive?
It seems like in both sets of cases, the courts largely deferred to the executive branch's power, wouldn't you say? They upheld broad interpretations of the statutes Congress wrote, giving the president significant flexibility.
Yeah, generally.
Whether it was the ability to adjust Section 232 tariffs over time, as the Federal Circuit found in Trans-Pacific Steel, or the broad authority of USTR to impose Section 301 tariffs in response to foreign actions, as the CIT found. That's right. They affirmed the executive had a lot of room to operate within these statutes. However, there was that crucial distinction you pointed out earlier about process.
Yes, exactly. While they largely upheld the substance of the power, they did impose checks on the process. In the Section 301 cases, the court required the USTR to go back and fix its administrative procedure by adequately responding to public comments under the APA. So maybe deference on the policy substance, but insistence on procedural correctness under the law.
Exactly. It's a nuanced picture.
Yeah.
They weren't simply rubber stamping every executive action, but they were reluctant to overturn the core exercise of delegated power itself in these high-profile tariff disputes.
All right, let's reinforce a few key facts from this section with some quick flashcard points for memory.
Okay, Section 232.
National security tariffs, like those on steel and aluminum,
The AIS case.
upheld the constitutionality of Section 232's delegation of power based on the intelligible principle guide of finding a national security threat.
The Trans-Pacific Steel case.
The Federal Circuit reversed a lower court, allowing the executive broad flexibility in adjusting Section 232 tariffs over time.
Sections 301.
Tariffs imposed on China, initially targeting unfair trade practices, later expanded.
In Section 301 at the CIT.
Upheld the USTR's broad statutory authority to impose and expand the tariffs, but required the agency to fix procedural issues under the APA regarding public comments.
And WTO findings related to these cases.
Did not automatically force U.S. courts or policy to change tariffs that were upheld under U.S. domestic law.
Good summary.
So we've seen where courts generally lean towards upholding executive authority within the bounds of existing trade statutes, albeit with a check on procedure. Now let's explore instances where courts drew clear lines, testing the absolute limits of executive power, including in areas maybe less traditionally associated with tariffs.
Another area where federal judges have had to draw lines involves safeguard tariffs.
Safeguards. What are those exactly?
These are temporary duties, authorized by Section 201 of the Trade Act of 1974, designed to protect domestic industries from unexpected surges in imports that cause or threaten serious injury. Temporary relief, basically.
And a significant legal battle here involved solar panels. I remember reading about that.
Yes. In 2018, President Trump imposed a 4-year safeguard tariff on certain solar panel imports. The tariff rate was set to decline over that period. Initially, the administration excluded bifacial solar panels.
The double-sided ones.
Right, which can generate electricity from both sides, recognizing they were a distinct product, often used in larger utility-scale projects.
But that exemption became contentious. People didn't like it.
It did. As domestic solar panel manufacturers expressed concerns about the exemption, the USTR, under the Trump administration, attempted to withdraw that exclusion for bifacial panels and even increase the tariff rate for the 4th year of the safeguard from 15% back up to 18%.
Wow, okay.
This action led to a legal challenge from solar energy companies and importers, in the case Invenergy Renewables, LLC et al. United States.
What was the core legal question the court had to decide here? What was the fight about?
The challenge hinged on Section 204 of the Trade Act, which gives the president authority to reduce, modify, or terminate a safeguard measure.
Reduce, modify, or terminate.
The critical question was, does the word modify in that statute allow the president to make the safeguard more restrictive by adding panels back in, or increasing the rate, or only less restrictive?
Ah, the meaning of modify. And how did the CIT rule in this case?
In November 2021, Judge Gary Katzman at the CIT struck down the Trump administration's attempt to expand the solar tariffs and withdraw the exemption.
He struck it down. Why?
He adopted a reasoning that focused on the purpose of Section 204. He reasoned that Section 204 was intended by Congress as an escape hatch, a tool to liberalize or ease trade measures as a domestic industry recovered, not to tighten them again unilaterally.
So he looked beyond just the literal meaning of modify and considered the overall aim of the law, the spirit of the law.
It's exactly. Judge Katzman found no indication in the statute that the executive could make a safeguard more restrictive once it was in place using Section 204. He also noted the administration hadn't followed all the procedural steps required elsewhere in the law, like evaluating the industry's condition.
I see.
Reading the statute in the context of its purpose, phasing out protection, he concluded the exemption couldn't be revoked and the rate couldn't be increased under this section. It's a bit like saying Congress gave the president a tool specifically designed to open the cage door, and the court said, you can't use that tool to close it tighter.
That ruling must have been a significant win for the renewable energy sector and importers at the time.
It was. The court ordered customs to stop collecting the higher duties, providing immediate relief. The decision was seen as a strong statement that even broad grants of flexibility in trade remedies have limits tied to the statute's intended purpose and required procedures.
But the story didn't end there, right? I feel like I remember this going back and forth.
No, you're right. It didn't end there. The U.S. government, under the Biden administration, which had inherited the defense of the Trump action, appealed the CIT's ruling to the Federal Circuit. And in a significant development in late 2023, the Federal Circuit overturned the CIT's decision and upheld the president's authority to make those modifications.
They overturned it. How did the appellate court reach the opposite conclusion?
The Federal Circuit panel, writing through Judge Leonard Stark, looked at the same statutory language, reduce, modify, or terminate, but took a different approach. They applied a very deferential standard of review, asking if the president's interpretation that modify allowed trade restricting changes was a clear misconstruction.
A clear misconstruction.
Okay. Judge Stark found that the statutory text did unambiguously bar increasing a safeguard tariff or withdrawing an exclusion. Therefore, the president's reading wasn't a clear misinterpretation.
So, while the CIT focused on the statute's purpose, the Federal Circuit focused strictly on the text, and if the text wasn't crystal clear in forbidding the action, they gave deference to the executive. It's like the appellate court looked at that cage door language and said, well, modify is a bit ambiguous. Maybe it could mean both opening and closing. The text doesn't clearly say, you can only open it.
Precisely. This highlights a key difference in judicial approaches. While trial courts like the CIT might be more inclined to interpret statutes in line with their legislative history or purpose, appellate courts often stick more strictly to the statutory text and give more deference to executive discretion if the text isn't crystal clear in imposing limitations.
So what happened then?
This Federal Circuit decision, while the specific solar tariffs had expired by then, legally validated the earlier action and provided a precedent for future presidents seeking similar flexibility. It also underscored that if Congress wants to limit the president's options under a trade statute, it needs to be very explicit in the law's text.
Got it. The key takeaway from the Invenergy Solar Safeguard case is that while the CIT tried to limit executive power based on the statute's purpose, the Federal Circuit reversed, focusing on the statutory text and allowing the executive broader flexibility to modify safeguards, including making them more restrictive.
Now let's turn to instances where courts drew a much firmer, indeed almost absolute, line. This happened when the executive branch tried to use laws not traditionally intended for imposing broad tariffs. A dramatic example came during a late-term push by the Trump administration to use the International Emergency Economic Powers Act, IEEPA, for tariff actions.
Wait, IEPA. I thought IEP was primarily for things like sanctions or freezing assets during a national emergency, not imposing tariffs. That doesn't sound right.
You are exactly right. And historically, presidents had not used IEPA to levy broad tariffs. But in 2020, President Trump issued proclamations using IEP to impose what he called worldwide tariffs against countries with significant trade imbalances and trafficking tariffs on imports from China, Mexico, and Canada, framed as addressing the fentanyl crisis.
Wow.
This was a novel and unprecedented use of a national emergency statute for what amounted to significant import taxes,
And this was challenged by importers and even some states, I imagine.
leading to a very significant decision by the CIT in May 2025, the case of VOS Selections, Inc. of the United States. A three-judge panel at the CIT emphatically struck down these IEEB-based tariffs.
Emphatically struck them down. What was the court's reasoning for drawing such a hard line here?
The court's core holding was that IEEPA simply does not grant the president the authority to impose broad tariffs. The judges looked closely at the text and history of IEEPA. They noted that when Congress enacted IEP in 1977, it was designed to rein in presidential emergency economic powers compared to an older wartime law, the Trading with the Enemy Act,
PWEA.
which President Nixon had controversially used in 1971 to impose a 10% import surcharge. Congress deliberately did not include tariff authority in IEP.
So Congress intentionally withheld that power from IEPA when they wrote the law.
Yes, that was the court's finding. They pointed out that unlike other specific trade laws like Section 232, Section 301, or Section 201, IEEPA doesn't mention tariffs at all. Furthermore, they highlighted that if the president wanted to impose temporary tariffs for balance of payments, he issues the rationale for the worldwide tariffs. Congress had provided a specific tool for that in Section 122 of the 1974 Trade Act, which has its own limits. The court viewed the attempt to use IEEPA for these purposes as an unlawful attempt to bypass those specific trade statutes.
It sounds like the court saw this as the executive trying to use the wrong key for the lock Congress had built. That seems like a good way to put it.
That's a good analogy, yeah. The court saw it as the president trying to use a broad skeleton key, IEEPA, to open a door, tariff policy, that Congress had equipped with very specific locks, other trade statutes. The court said, no, that key doesn't fit, and trying to use it this way is unlawful.
Did they mention the Constitution?
They also raised a constitutional point. If IEEPA were read to allow unlimited tariffs, it would likely be an unconstitutional delegation of Congress's exclusive power to tax and set tariffs. To avoid that constitutional problem, they interpreted IEEPA not to include tariff authority.
This was a very strong ruling against the executive then,
Yeah.
really drawing a line.
It was. The CIT invalidated the emergency tariff orders and ordered that further collection be stopped. This decision carries profound implications. Domestically, it was a major win for the plaintiffs and more broadly for the principle of separation of powers, firmly reasserting Congress's primary role in setting tariffs. It's a relatively rare instance of a court declaring an executive trade action to be ultra vires, meaning beyond legal authority altogether.
And internationally, what was the impact? Did this prevent bigger problems?
Internationally, this ruling likely prevented a major escalation in trade tensions. Had these IEEPA tariffs gone into effect, they would have hit imports globally, including from key allies like Canada and Mexico, potentially triggering retaliation and challenges under agreements like USMCA. By striking them down, the court arguably averted another significant shock to the global trading system.
Okay. The key takeaway from the VOS selections case at the CIT is that the court drew a hard line, striking down the use of IEPA for broad tariffs, viewing it as an unlawful attempt to bypass specific trade laws and an unconstitutional delegation of Congress's power.
Right. Now, the government has appealed this ruling to the Federal Circuit. The Federal Circuit has temporarily paused or stayed the CIT's injunction. meaning the contested tariffs remain on hold pending the appeal's outcome. This sets the stage for a potentially landmark appellate decision on the boundaries of presidential emergency economic powers.
And it's worth noting that around the same time, courts were also intervening to check executive actions that weren't traditional tariffs, but used similar broad authorities to restrict commerce, right? Like with tech apps.
Yes, absolutely. For example, in 2020, federal district court judges blocked the Trump administration's attempts to ban the Chinese-owned apps WeChat and TikTok.
Ah, yes, I remember that.
In those cases, the courts found the proposed bans likely exceeded the authority granted under IEEPA, which specifically says the president cannot restrict personal communications technology and also raised serious First Amendment concerns, granting injunctions to stop the bans.
So when we look at the VOS selections case together with these tech ban cases, what does it tell us about the court's willingness to intervene overall?
It shows that while courts often uphold the president's flexibility within the clear boundaries of trade statutes, they're willing to step in and intervene when an administration's actions are seen as completely outside the scope of the delegated authority, like using IEP for tariffs, or when they run afoul of broader fundamental legal protections, such as constitutional rights like the First Amendment.
Let's bring this chapter to a close with a look back at the cases where courts drew these clearer lines.
Okay. We covered the solar safeguard case in Venergy, where the CIT initially tried to limit executive power based on the statute's purpose. But the Federal Circuit ultimately allowed more executive flexibility by focusing strictly on the statutory text. This highlighted the appellate level's tendency to restore broader executive leeway.
And in contrast, we discussed the IEEPA tariff case, VOS selections, where the CIT drew a very clear line, striking down the executive action entirely as being beyond statutory authority and an unlawful maneuver around Congress's power over tariffs, a much stronger check.
These cases, along with examples like the tech ban injunctions, show that while courts might uphold executive power exercised within statutes, they will check actions that are perceived as completely outside the bounds of the delegated power or that violate fundamental rights.
Okay, let's capture some flashcard facts from this chapter.
Safeguard tariffs, Section 201.
Temporary duties under Section 201 meant to protect domestic industries from import surges.
The Invenergy case.
The CIT tried to limit the executive's power to increase solar safeguard tariffs based on statutory purpose, but the Federal Circuit reversed, allowing more executive flexibility based on the statute's text.
IEEPA.
The International Emergency Economic Powers Act, primarily for sanctions, not traditionally tariffs,
The VOS selections case at the CIT.
struck down IEEPA-based tariffs as unlawful and an unconstitutional delegation, declaring the executive action ultra vires, or beyond legal authority.
And the WeChat TikTok bans.
Federal district courts blocked these proposed bans, finding they likely exceeded IEEPA authority and violated First Amendment rights, showing courts checking actions outside delegated power or violating rights.
Good set of takeaways.
Okay, we've seen courts act as referees in specific trade disputes, sometimes deferring, sometimes drawing lines. Now we're moving into a truly seismic shift that changes the fundamental rules of how courts review any agency action, including those related to trade. Let's dive into the Chevron doctrine, its history, and its dramatic overruling. This feels like a big one.
It is a huge one. The Chevron doctrine is, or maybe was, a cornerstone of modern administrative law, originating from the Supreme Court's 1984 decision in Chevron USA, Inc. v. Natural Resources Defense Council.
Chevron, right. Heard that name a lot.
It established a framework where federal courts would typically defer to administrative agencies' interpretations of statutes that they administer, but only if those statutes are ambiguous.
Okay, wait. Why would courts defer to agencies? Wouldn't judges want to decide what the law means themselves?
Well, the core idea was this. When Congress passes a law, sometimes the language isn't perfectly clear on every single point. There are gaps or ambiguities. Under Chevron, the Supreme Court said that when Congress leaves these gaps, it implicitly intends for the expert agency administering the law to fill them.
Okay.
Courts should respect the agency's interpretation, provided it's a reasonable way to read the ambiguous statute.
So it acknowledged that agencies have more technical knowledge than judges do. Is that the idea? Expertise.
Exactly. It recognized that agencies, being part of the executive branch, often have specialized expertise in complex areas: environmental alliance, financial markets, trade regulation, agriculture that courts lack. And agencies are also seen as more politically accountable than unelected judges, through the president.
Oh, accountability.
So Chevron said, in those ambiguous areas, the agency gets to make the call, and courts should generally go along with it if it's reasonable. It's like saying, if Congress gives you a roadmap with some sections left blank, the agency with the best knowledge of the terrain gets to draw those roads, and the courts just check that the drawing isn't completely unreasonable or driving off the road entirely.
And there was that famous two-step test to decide if an agency's interpretation got this deference. How did that work?
Yes, the now iconic Chevron two-step. Step 1. Is the statute clear? Has Congress directly and unambiguously spoken to the precise question at issue? If the text is clear, that's the end of the analysis. Both the court and the agency must follow Congress's clear command. No room for agency discretion there.
Okay, clear law, follow the law. Makes sense. So step 2 only comes into play if the law isn't clear, if it's ambiguous.
Exactly. If the statute is silent or ambiguous on this specific point, the court doesn't just substitute its own preferred interpretation. Instead, it moves to step 2 and asks, is the agency's interpretation of that ambiguous language based on a permissible construction of the statute?
Permissible construction.
If the agency's reading is reasonable and not contrary to the overall law, the court upholds it. Even if the judge thinks there might be a better way to interpret it, they defer to the agency's reasonable choice.
That sounds like a powerful tool for agencies. Gave them a lot of influence over how laws were actually applied.
It was. Chevron became a cornerstone of administrative law. It was cited in thousands of judicial decisions and shaped how agencies operated and how courts review them for decades. Provided a degree of predictability. If Congress left a law ambiguous, agencies knew they had leeway to interpret it, relying on their expertise, and courts would generally defer to a reasonable reading.
And Congress started writing laws knowing Chevron was the rule, like they'd intentionally leave gaps.
Yes, often legislation would be written in broader terms, leaving the technical details or policy choices in ambiguous areas to the agencies, knowing that under Chevron, those agency interpretations would likely be given deference by the courts.
But eventually, critiques of Chevron grew louder. People started questioning this deference.
Absolutely, particularly in the last decade or so. Critics, often concerned about the growth of the administrative state, the vast network of federal agencies, argued that Chevron gave too much power to unelected bureaucrats. They felt judges should have the final say on interpreting the law, not agencies. They argued it encouraged agencies to stretch the limits of vague statutes to expand their own power.
What did those who defended Chevron say? Why keep it?
They argue Chevron struck the right balance, recognizing that agencies have the technical expertise and democratic accountability through the president that courts lack. They saw Chevron as respecting Congress's likely intent. When Congress leaves ambiguity in a complex area, it means for the expert agency to make the informed policy judgment call, subject to the court checking for reasonableness.
Okay.
And even the Supreme Court itself started applying it less consistently. It wasn't always the go-to rule.
Yes, that was a key sign. In recent years, the court seemed to avoid applying Chevron deference in major high-stakes cases. There were periods where the court hadn't explicitly relied on Chevron in a majority opinion for several years before it was overturned.
Wow.
This, coupled with the rise of doctrines like the major questions doctrine, which requires clear authorization for actions of great significance, signaled that Chevron's foundations were becoming unstable, setting the stage for a direct challenge.
Okay, let's take a moment to recap the journey of Chevron. We've seen how it started in 1984, creating this doctrine of judicial deference to agency interpretations of ambiguous statutes, guided by that two-step test.
Right.
It grew into a cornerstone of administrative law, influencing how agencies and Congress operated. But it also faced increasing criticism and inconsistent application, weakening its standing.
That's a good summary. It was a truly pivotal doctrine that structured the relationship between courts and agencies for 40 years, giving agencies significant interpretive power in gray areas of the law. As you reflect on that history, the debate between giving expert agencies leeway versus judges having the final say on what the law means, which side of that argument resonates more with you? Agency expertise or judicial finality?
That's a tough one, and it brings us to the dramatic end of the Chevron story. Let's talk about Loper Bright v. Raimondo in 2024.
Yeah.
This was the case, wasn't it?
This was the case. In June 2024, the Supreme Court delivered a landmark decision in Loper Bright Enterprises v. Raimondo. They explicitly and definitively overruled the Chevron doctrine. This case originated from a challenge to a regulation by the National Marine Fisheries Service. The regulation required the fishing industry to pay for independent monitors to be on board their boats.
And the fishing companies argued the agency didn't have the power to make them pay, that wasn't in the law.
Exactly. They argued the law, the Magnuson-Stevens Act, didn't clearly authorize the agency to force the industry to fund the monitors. They specifically asked the Supreme Court to overrule Chevron, or at least carve out an exception for this type of question.
What happened in the lower courts before it reached the Supreme Court? Did they apply Chevron?
They did. The lower courts, applying Chevron deference, found the statute was ambiguous on the funding question. Since the agency's interpretation requiring the industry to pay was deemed reasonable under Chevron Step 2, the lower courts upheld the regulation.
But the Supreme Court decided to take the case specifically to reconsider Chevron itself.
Yes, that was the crucial point. The court granted review only on the question of Chevron's validity. They used this specific case as the vehicle to re-examine whether that 40-year-old precedent should stand.
And the decision was overruled, just like that.
Overruled outright.
Yeah.
Chief Justice John Roberts wrote for a 6-3 majority. The court held that the Administrative Procedure Act, the APA, the core law governing how agencies act and courts review them, requires courts to exercise their independent judgment when deciding if an agency's action is within the law.
Independent judgment.
The court stated definitively that courts may not defer to an agency interpretation of the law simply because a statute is ambiguous. And the core holding was stark. Chevron is overruled.
Wow. So agency interpretations of ambiguous laws are no longer entitled to this special deference. It's just gone.
That's the new reality. Under the APA, the court said agency interpretations are not entitled to deference. Instead, it is the court's job to determine the best reading of the statute. The idea that statutory ambiguities are implicit delegations to agencies was firmly rejected. The court stated that letting ambiguity give power to agencies cannot be reconciled with the APA and the judiciary's fundamental constitutional role. It's like the court said, we're not just checking if the agency's road drawing is reasonable anymore. We are taking the map and drawing the roads ourselves.
Okay, so what was the legal reasoning the majority used to justify overturning such a major precedent? It had been around for 40 years.
The majority laid out 3 main reasons. First, they looked at the text and history of the APA from 1946, arguing it required courts to exercise their own independent judgment, and that Chevron-like deference wasn't recognized before the APA or established by it.
Okay, the APA text. What else?
Second, and perhaps most fundamentally, they cited the Constitution, Article 3, which establishes the judicial branch. Quoting the famous Marbury v. Madison case, Roberts emphasized it is the duty of the judiciary to say what the law is.
Marbury, right.
The court argued that Chevron forced judges to abandon this duty by requiring them to accept an agency's interpretation, even if the judge thought it was wrong. This, they said, was incompatible with the separation of powers. Justice Clarence Thomas, in a separate opinion, went further, stating Chevron violates our Constitution's separation of powers by making judges cede their judgment to the executive branch.
Strong words. And the third reason?
The third reason was practical. The court argued Chevron was unworkable and problematic in practice. Roberts said deciding whether a statute is truly ambiguous had proven difficult and subjective over the years. He noted the court had constantly tinkered with Chevron and hadn't actually relied on it in a majority opinion for about 8 years before this case.
Unworkable.
Because it was seen as unworkable and the court hadn't strictly relied on it recently, they didn't feel bound by stare decisis, the principle of respecting precedent. They also felt Chevron undermined the rule of law by allowing agencies to change policy interpretations even when Congress hadn't given them clear authority to do so.
So, if courts aren't deferring to agency interpretations of ambiguous laws anymore, what standard will they use? How do they decide now?
Under the new post-Chevron standard, courts will now independently determine the meaning of a statute, even if it's ambiguous. However, they can still consider the agency's interpretation. The court favorably cited an older case, Skidmore v. Swift & Co. from 1944.
Skidmore, okay.
Under Skidmore, an agency's view might be persuasive, depending on factors like the agency's expertise, the thoroughness of its consideration, and the consistency of its position.
So agencies can still offer their interpretation, and a judge might find it convincing, but it doesn't get that special thumb on the scale that Chevron provided. No automatic deference.
Exactly. The agency's view isn't controlling. It's persuasive if the judge finds it so after doing their own independent legal analysis. The court did clarify that Congress can still explicitly delegate interpretive authority to an agency in a statute, for example, if a law says the secretary shall define a certain term. When Congress does that clearly, Courts will respect that specific delegation and review the agency's action to make sure it's faithful to that delegated task. But absent that kind of express delegation, courts will interpret the statute themselves, even if it's ambiguous.
Got it. Now, Justice Elena Kagan wrote a very strong dissenting opinion against overturning Chevron, didn't she? What was her argument?
She did, joined by Justices Sotomayor and Jackson in a related case. Kagan described the decision as a dramatic judicial power grab and criticized the majority for abandoning a precedent she felt was crucial and correct.
A power grab.
Her argument was that Chevron wasn't about judges being lazy. It was about respecting Congress's decision to put primary authority over complex regulatory matters with expert agencies. When Congress leaves ambiguities, she argued, it intended agencies to fill them using their knowledge.
She emphasized the agency's expertise and accountability then.
Yes. Kagan argued agencies have the technical and policy expertise courts lack, and they are accountable through the president, unlike courts. She saw Chevron as reflecting a presumption that Congress wanted agencies to make judgment calls on ambiguities, with courts only stepping in if the agency was being unreasonable. She felt the majority was now putting judges in the position of making policy decisions they aren't equipped or authorized to make.
She also defended Chevron's role in the legal system, its history.
Forcefully. Kagan stated that Chevron had been the backdrop for how Congress, agencies, courts, and businesses operated for 40 years. Overturning it, she warned, was a massive shock to the legal system that would cast doubt on many settled constructions of statutes, creating uncertainty and instability.
What about the real-world problems she foresaw?
She gave examples of highly technical questions agencies deal with, like defining protein or what makes a wildlife population distinct. Under Chevron, agencies used their expertise, and courts upheld their reasonable interpretations. Now, she argued, judges without that expertise will decide, potentially leading to inconsistent outcomes and regulatory chaos. She saw it leading to more litigation, circuit splits, and pressure on the Supreme Court itself.
And she viewed the majority's action pretty critically, it sounds.
Very critically. What the majority called restoring the judicial duty, Kagan called judicial hubris. She argued the court was turning itself into the country's administrative czar, seizing power over every statutory ambiguity, regardless of whether it was a highly technical or policy-laden question. She felt the majority disregarded stare decisis and democratic accountability, discarding a functional doctrine for the sake of expanding its own power.
And was she skeptical that prior cases decided under Chevron would remain unaffected? Did she think this would reopen old wounds?
Yes. While the majority suggested they were only changing the method of interpretation, not necessarily the outcomes of past cases decided under Chevron, Kagan doubted this. She felt courts wanting to overturn an old interpretation would find ways to do so. She also predicted that the new Skidmore standard, where agency views are just persuasive, would create its own new areas of legal dispute. Her overall view was that the decision was destabilizing, unwarranted, and a power shift Congress never intended.
Wow. Okay, so to recap the full story of Chevron, it started in 1984, establishing that principle of judicial deference to agency interpretations of ambiguous laws, using that two-step test. It became incredibly influential, but faced rising challenges and inconsistent application.
And then in Loper-Bright in 2024, the Supreme Court, in a 6-3 decision, overturned Chevron completely, a really big moment.
This marks a dramatic shift. Instead of courts deferring to an agency's reasonable interpretation of ambiguous language, courts must now decide the best interpretation themselves, only considering the agency's view for its potential to be persuasive, as laid out in that older Skidmore case.
The majority justified this based on the APA, the Constitution's requirement for independent judicial judgment, and finding Chevron unworkable.
While the dissent warned of a judicial power grab, a loss of necessary agency expertise, significant legal instability, and a disregard for Congress's intent when leaving ambiguities for agencies to resolve.
Let's distill some flashcard facts about this seismic shift.
Chevron, 1984.
Doctrine of judicial deference to agency interpretations of ambiguous statutes.
Chevron two-step.
1, is statute clear? If no. 2, is agency interpretation reasonable?
Loper-Bright, 2024.
The Supreme Court case that overruled Chevron by a 6-3 vote.
Majority reasoning in Loper-Bright.
Cited the APA requirement for independent judgment, Article 3, judicial duty. Chevron was unworkable.
Post-Chevron standard.
Courts decide statutory meaning independently. Agency views are only persuasive. Skidmore.
Dissent warning in Loper-Bright.
Warned of loss of expertise, instability, judicial hubris, disregard for congressional intent.
Thinking about this fundamental change, If the map now has blank spots, and the courts are saying they are taking back the pen from the agencies to draw those roads, which argument about this shift feels more significant to you? The idea that courts are reclaiming their proper role in interpreting law, or the concern that judges might lack the expertise for complex technical or policy issues agencies handle, potentially creating less informed or inconsistent outcomes?
It's a huge question. It's a change that alters the fundamental plumbing of how law is administered in the US. And this dramatic shift in judicial review brings us to another key force that has been actively pushing for exactly this kind of change. Legal challengers, particularly the rise of public interest law firms like the New Civil Liberties Alliance or NCLA.
We've definitely seen an increasing prominence of these kinds of public interest law firms challenging governmental actions, often focusing on agencies, haven't we?
Yes, that's a significant trend. Organizations like NCLA have emerged as dedicated players in the legal landscape, specifically targeting what they often refer to as the administrative state. They've become key actors in filing lawsuits against federal agencies and their regulations.
And a key part of their model is providing legal services pro bono, for free.
Absolutely. A substantial amount of their work is done on a pro bono basis. This is crucial because it allows them to represent individuals and businesses who might otherwise lack the enormous financial resources needed to mount complex, multi-year legal challenges against the vast resources of the federal government.
And these challenges often seem to be about more than just one specific regulation impacting one specific client. They seem bigger.
That's a critical point. These legal challenges frequently go beyond simply addressing a discrete harm to an individual client. They embody broader ideological critiques of government power itself, of the regulatory frameworks that have developed over decades, and of the constitutional balance between the branches. Federal trade actions, because they often involve significant executive or agency decisions with broad economic and policy implications, have become a particularly fertile ground for these legal and ideological confrontations.
So they see trade policy as a place to fight bigger battles, like a strategic venue.
Exactly. For organizations like NCLA, trade policy isn't just about economic tariffs or international relations. It's seen as a critical arena where fundamental questions about the legitimate scope of government, the separation of powers, and individual liberties, particularly economic liberties, are contested.
Right.
When NCLA litigates against a tariff or an agency regulation impacting commerce, it's often doing so not just because of the specific impact of that rule, but because it's a vehicle for advancing a deeper constitutional argument about limiting the power of government agencies. This turns federal trade actions into a strategic forum for ideological contestation.
And their funding structure enables them to pursue these long-term goals, I guess, the pro bono aspect.
It does. Relying on pro bono services, often funded by donors who share their ideological perspective, is key. Challenging the federal government on constitutional grounds requires sustained effort and significant resources. NCLA, for instance, operates pro bono and receives funding from foundations aligned with conservative and libertarian viewpoints, such as the Charles Koch Foundation, Donors Trust, and the Lynd and Harry Bradley Foundation.
So the decision to file a lawsuit isn't solely dependent on whether a specific client can afford it. It's more about the mission.
Precisely. This model allows these nonprofits to strategically select cases that best serve their broader mission of challenging the administrative state, even if the direct economic stake for the immediate plaintiff might not justify the cost of litigation in a traditional model. It enables a more consistent, long-term legal campaign against aspects of the administrative state, including actions impacting trade and commerce, aligning with the organization's core ideological objectives.
Let's talk specifically about the NCLA. It was founded fairly recently, wasn't it?
Yes. The New Civil Liberties Alliance was founded in 2017 by the legal scholar Philip Hamburger. Its very mission statement highlights its agenda to protect constitutional freedoms from what it sees as violations by the administrative state.
Okay.
NCLA represents a specific current within public interest litigation, one that is deeply skeptical of expansive administrative power and seeks to challenge it on fundamental legal grounds.
They view the administrative state itself as the main threat. Is that fair to say?
Absolutely. Their framing is quite direct. They position the administrative state not just as a part of modern government, but as a serious threat to constitutional freedoms, and, in their view, fundamentally unconstitutional. Their proposed solution is clear and concise. Let judges judge, let legislators legislate, stop bureaucrats from doing either.
Wow. Okay. What are the core legal and philosophical principles that drive NCLA's approach?
Right.
What's their foundation?
At its heart is a specific view of American constitutionalism. This includes a strong adherence to principles they believe prevent arbitrary governmental power and a commitment to what they see as the original meaning of the Constitution, arguing against interpretations that expand government authority beyond its initial scope.
And they often emphasize Congress's role in Article 1, the legislative power.
Yes, a key tenet for them is the language in Article 1, Section 1 of the Constitution, which states, "All legislative powers herein granted shall be vested in a Congress of the United States." NCLA interprets this as a strict prohibition against Congress delegating core legislative powers, like the power to tax, regulate commerce, or impose tariffs to executive branch agencies.
Right, the non-delegation idea.
This perspective is a foundation for many of their challenges to agency rules and executive orders, including those in the trade context.
Does their viewpoint extend beyond just administrative law structure? Are there other areas?
It does. Their ideological stance reflects a broader skepticism of expansive federal power, including in fiscal matters. They've voiced concerns about federal spending they view as exceeding constitutional limits and high income tax rates, signaling a wider commitment to limited government and fiscal conservatism.
So, when they challenge a trade action, the focus is less on the economic policy itself and more on the underlying authority. It's about the how, not the what.
Correct. In the context of federal trade actions, their primary focus is often less on whether a specific tariff rate or regulation is good policy economically, and more on the fundamental question of the process and constitutional authority by which that action was taken. They are challenging the legitimacy of the mechanism itself.
And Philip Hamburger scholarship provides the intellectual foundation for all this.
Yes, his extensive academic work on the administrative state and constitutionalism gives NCLA a deep, consistent intellectual framework. Their lawsuits aren't isolated actions. They're part of a larger, theoretically grounded project to challenge and potentially dismantle aspects of the modern administrative state. This scholarly coherence can lend weight to their arguments, particularly when presented to courts or audiences sympathetic to originalist or textualist legal interpretations. It also helps define their identity and attract like-minded support.
NCLA describes itself as nonpartisan. How should we understand that label in this context? Does it mean neutral?
Well, while they use the term nonpartisan, their explicit mission statement, their funding sources, and the consistent nature of their legal arguments, particularly the critique of the administrative state and the emphasis on constitutional originalism, align closely with conservative and libertarian legal and political viewpoints. The nonpartisan designation likely means they don't formally affiliate with a political party, rather than indicating ideological neutrality. Their specific focus on the administrative state as the primary threat is what defines their particular approach within the broader civil liberties landscape.
Who are some of the key people involved?
Philip Hamburger is the founder and CEO, providing the core intellectual vision. Mark Chenoweth is president and chief legal officer. What's interesting about Mark Chenoweth is his background. He has significant experience working within the federal government.
Oh, interesting. An insider's perspective.
Right. This insider perspective can be incredibly strategic for NCLA, giving them a nuanced understanding of how agencies operate and allowing them to identify procedural vulnerabilities and craft very targeted legal challenges. It's almost an inversion of the typical government revolving door. Here, the experience is used to critique and challenge the system from the outside. Zonette Brown is their general counsel. They also have a team of experienced litigation counsel.
And they have advisors as well.
Yes, they have a 30-member bipartisan board of advisors, which includes retired federal judges and former public officials. According to NCLA, these advisors share a commitment to protecting civil liberties against what NCLA calls the administrative state's depredations and provide advice and counsel. As we mentioned, their operations are sustained from donations, notably from foundations like the Koch Foundation, Donors Trust, and the Bradley Foundation, whose missions align with NCLA's focus on limited government and challenging regulatory power.
Okay, let's take a moment here to do a quick recap on the role of these legal challengers like NCLA.
Good idea. We've summarized the rise and increasing significance of public interest law firms like NCLA in challenging federal government actions, especially those impacting trade. We explained their core motivation, an ideological critique viewing the administrative state as unconstitutional and a threat to liberties.
Right. We highlighted their unique operational model pro bono work, often underwritten by donor funding, enabling them to pursue strategic long-term litigation against government power.
And we specifically introduced NCLA, founded by Philip Hamburger, detailing its mission to tame the unbridled power of agencies, identifying key figures like Mark Chenoweth and explaining its funding. We also discussed their nonpartisan label and how their focus is less on specific policy outcomes and more on the constitutional authority and process of government action.
Okay, here are some flashcard facts to solidify this understanding.
Public interest firms.
Increasingly challenging government actions, often pro bono, driven by broader ideological critiques of the administrative state.
NCLA.
The new Civil Liberties Alliance, founded in 2017 by Philip Hamburger,
NCLA mission.
tamed the unbridled power of state and federal agencies, viewing the administrative state as a fundamentally unconstitutional threat to civil liberties and seeking to limit bureaucratic power.
NCLA funding.
Relies on donations, notably from sources like the Charles Koch Foundation, which supports their long-term litigation strategy against the administrative state.
NCLA focus.
Less on specific policy outcomes, like a tariff rate, and more on challenging the constitutional authority and the administrative process by which government actions, including trade measures, are taken.
Philip Hamburger.
NCLA founder and CEO provides the key scholarly basis for their critique of the administrative state.
Now that we understand who NCLA is and what drives them, let's look at their specific legal playbook, the constitutional doctrines and arguments they deploy in battles against agencies. What's their strategy?
A central element of NCLA's strategy is invoking foundational constitutional doctrines to challenge the legality of federal actions, particularly those by agencies. This is their primary legal weapon.
And a key one they frequently use is the non-delegation doctrine. That keeps coming up.
Absolutely. NCLA often argues that Congress has unconstitutionally delegated its essential legislative powers like taxing, regulating commerce, or setting tariffs to executive agencies or the president, without providing a sufficiently clear, intelligible principle to guide that discretion.
Like they argued in those IEEPA tariff challenges we discussed earlier.
Exactly. Their argument was that if IEP were read to grant the president the power to impose tariffs, the statute itself lacks an intelligible principle to guide that vast power, making it an unconstitutional delegation from Congress.
Okay.
NCLA aims to revive and strengthen this doctrine, which courts have historically used sparingly, but which is seeing renewed interest from some judges. If successful, it could drastically reshape the balance of power by requiring Congress to be much more specific when granting authority to the executive.
They also pair this with the major questions doctrine, right? Using both.
Yes, these doctrines often work together in NCLA's arguments. NCLA contends that administrative actions that have vast economic and political significance and large-scale tariff regimes certainly fit that description, require explicit, unambiguous authorization from Congress.
Explicit authorization.
They argue that agencies or the president cannot rely on vague or general statutes, like IEPA, to take such significant actions.
And this doctrine has been gaining traction recently, particularly at the Supreme Court. We saw that with Chevron, too.
It has. The Supreme Court has increasingly used the major questions doctrine to cabin agency power, requiring clear statements from Congress for actions of major significance. This provides NCLA with a powerful tool to argue for narrower interpretations of agency authority and to demand that Congress provide clear mandates when it intends to authorize significant policies, including major trade actions.
What about challenges based on due process? How does that fit in?
NCLA also brings challenges based on alleged violations of due process rights. They often target the procedures used by agencies in enforcement actions or within administrative tribunals, arguing these settings can deny individuals and businesses fundamental fairness.
Like a fair hearing.
Exactly, such as the right to an impartial hearing or elements of trial rights, like a jury trial, that are available in traditional courts but often absent in administrative settings. This raises questions about the fairness and legitimacy of administrative enforcement mechanisms used by agencies across the government, including those that impact commerce.
And underlying many of these specific arguments is the broader principle of separation of powers. That seems foundational.
Fundamentally, yes. This is foundational to NCLA's entire project. They argue that the modern administrative state, by combining functions often seen as legislative, like rulemaking, executive, like enforcement, and judicial, like administrative adjudication, within a single agency, violates the Constitution's structural separation of powers.
So when they challenge tariffs,
When they challenge executive tariff making, they are questioning the president's ability to exercise powers they believe belong exclusively to Congress, like the power to tax and regulate commerce. This is their most sweeping challenge to the structure of contemporary American governance.
It sounds like they employ a strategy of using multiple arguments simultaneously, layering them.
Absolutely. It's a multi-layered approach, strategically deploying different doctrines in parallel. For example, in their challenges to the IEEPA tariffs, they didn't just make one argument. They argued first that the statute doesn't authorize tariffs at all.
Okay, step one.
Then, they argued if it did, it would be an unconstitutional delegation, non-delegation doctrine. And finally, they added that even if there was some authority, the significance of the action means the major questions doctrine requires a clearer statement from Congress that isn't there. It's like approaching a fortified position with several different types of siege weapons. If one doesn't breach the defenses, another might.
That approach gives them multiple paths to victory in court. Smart.
Exactly. It increases their chances of success because even if a court is hesitant to, say, fully revive the non-delegation doctrine, it might be receptive to a major questions argument or even just a narrower statutory interpretation argument. It allows them to maximize their potential success in individual cases while still advancing their broader agenda of challenging the administrative state.
Beyond these major constitutional doctrines, they also focus on challenging whether agencies have specific statutory authority at all, right? Just reading the law closely.
Yes. They meticulously examine the governing statutes, arguing that agencies frequently exceed the specific powers Congress has granted them. The argument that IEPA does not authorize tariffs is a prime example of this.
And they challenge guidance, too.
They also challenge what they call guidance abuse, where agencies issue non-binding guidance documents, but then treat and enforce them as if they were formal regulations, thereby bypassing the proper rulemaking procedures required by the APA. This was an argument NCLA made in the early stages of the RCALF USA cattle ear tag case.
Their goal is to strictly confine agencies to the powers explicitly given to them by Congress, no more, no less.
Through careful reading of the statute's text and consideration of Congress's intended scope. And finally, a key part of their playbook is also litigating issues of judicial deference and challenging the appropriate venue for cases.
They're openly opposed to judicial deference doctrines like Chevron, as we discussed.
Yes, very much so. NCLA has been a vocal critic of Chevron deference, arguing it forces judges to abandon their constitutional duty of independent legal judgment and creates an unfair bias in favor of the government in litigation.
And they strategically challenge where cases are heard. The venue matters.
We do. As we saw with the IEPA tariff cases, NCLA fought against the government's attempt to transfer those cases from generalist district courts to the Specialized Court of International Trade.
Why?
Their argument was that if, as they contend, IEPA is not a statute authorizing tariffs, then jurisdiction should lie in the district courts, whose purview is general federal law, not the CIT, whose jurisdiction is specifically tied to tariff laws.
That seems like a very strategic choice of battleground. Does it make a difference which court hears it?
It absolutely is. The venue can matter significantly. NCLA likely views generalist federal judges as potentially less inclined to defer to the executive or adopt expansive readings of statutes like IEPA, which aren't core trade laws, compared to judges on a specialized trade court. The jurisdictional battles are integral to creating the most favorable environment for their legal arguments.
Okay, let's quickly recap NCLA's legal playbook. Another micro recap here.
Sounds good. We've summarized NCLA's core legal strategies, deploying major constitutional doctrines like non-delegation, major questions, due process, and separation of powers to challenge government action. We highlighted their focus on meticulously challenging whether agencies have specific statutory authority for their actions and opposing practices like guidance abuse.
And we discussed their vocal opposition to judicial deference doctrines like Chevron and their strategic efforts to challenge the government's choice of venue, arguing for cases to be heard in forms they perceive as more favorable.
We emphasized their multi-layered approach, using several distinct legal arguments simultaneously to increase their chances of success while pursuing their overarching goal: to limit the power and scope of the administrative state, making trade actions a key battleground for this fundamental mission.
So as you consider NCLA's approach, using constitutional arguments to push back against agency power, which specific doctrine or argument do you find most compelling as a potential check on government authority? Is it the idea that Congress can't hand over too much power, non-delegation, that big actions need explicit okays, major questions, or that mixing powers in agencies violates the fundamental structure of government, separation of powers?
Now let's look at some specific high-profile cases where NCLA has deployed this playbook, showing their concrete impact on federal trade litigation and beyond. Where have we seen this in action?
A major target for NCLA's trade-related litigation has been President Trump's use of IEEPA to impose tariffs, which we discussed earlier as instances where courts drew hard lines.
Right, the IEPA fights.
The case simplified et al. V. Trump et al. Is a prime example of NCLA taking on this issue directly.
Yes. This case, also sometimes referred to by a lead plaintiff's name like Emily Lay Paper, Inke v. Trump, saw NCLA serving as lead counsel for a group of small business plaintiffs who were hit by those tariffs imposed under IEPA. Their legal arguments in this case were a clear demonstration of their multifaceted approach.
What were the key arguments NCLA made in challenging these IEPA tariffs? Walk us through their playbook in this case.
They argued, first and foremost, that IEPA simply lacks the statutory authority for the president to impose tariffs. They contended the law was designed for actions like sanctions or freezing assets during emergencies, and that there's no mention of tariffs in the text, nor had any president used it this way for nearly 50 years.
Okay, lack of authority. What else?
Second, they argued the president was usurping a power exclusively given to Congress by the Constitution, the power to levy taxes, including tariffs, and regulate foreign commerce under Article 1, Section 8.
The constitutional argument.
Beyond that, they invoked the major questions doctrine, arguing that tariffs of such widespread economic significance triggered this doctrine, requiring clear congressional authorization that IEEPA, in their view, utterly lacked. And as an alternative argument, they used the non-delegation doctrine, stating that if IEEPA were interpreted to permit tariffs, it would be an unconstitutional delegation because the statute provides no intelligible principle to limit such a vast power.
So, multiple constitutional challenges layered on top of the statutory one. And they even questioned the justification for using emergency powers in the first place. Was the emergency real?
Yes, NCLA's arguments also questioned whether the declared emergencies themselves, like the opioid crisis or trade deficits, were legitimate or necessary justifications for imposing tariffs under IEP's requirements, suggesting they were pretexts.
There was also that significant procedural battle over where the case should be heard, the venue fight.
Absolutely. NCLA strongly opposed the government's move to transfer the lawsuit from the Florida District Court where it was filed to the U.S. Court of International Trade. NCLA argued that the CIT lacked jurisdiction because, in their view, IEPA is not a statute that authorizes tariffs, and the CIT's jurisdiction is tied to laws specifically providing for tariffs.
Well, what was the result of that jurisdictional fight? Did NCLA win that?
Despite NCLA's arguments, the case was ultimately transferred to the CIT. NCLA filed an emergency motion to stay that transfer, but it was denied. While, as we discussed earlier, the CIT did ultimately rule against the IEPA tariffs in a separate case, VOS selections, and some district court rulings also initially enjoined the tariffs, the issue of proper venue was hotly contested by NCLA.
The simplified case seems to be a major test case for the boundaries of executive emergency power then. It hits all the big themes.
It is. It directly challenges the president's perceived ability to unilaterally impose significant financial burdens, essentially taxes, on Americans through the broad invocation of emergency powers. It raises fundamental questions about the separation of powers and the true limits of presidential authority in an area traditionally dominated by Congress.
In the emergency itself.
The debate over whether issues like trade deficits or public health crises can justify using an emergency statute for tariffs is central to these challenges. A definitive ruling limiting IEP for such purposes would have massive implications for executive power, potentially preventing future administrations from using emergency laws to implement major policies without clear backing from Congress.
NCLA was also involved in Learning Resources v. Trump, another case challenging IEP tariffs, though in a different court, right? Not as lead counsel.
Yes. In Learning Resources, NCLA didn't represent the direct plaintiffs, but participated by filing an amicus curiae brief, a friend of the court brief. Their brief specifically argued against the government's motion to transfer that case from the U.S. District Court for the District of Columbia to the CST.
So they were reinforcing their argument about the correct venue, trying to influence other cases.
Exactly. The core of their amicus brief was the same argument. The CIT lacks jurisdiction because IEPA does not authorize tariffs, and the government was engaging in blatant forum shopping to get the case before a specialized trade court. This intervention proved to be influential.
How so? Did it work in that case?
The judge in the D.C. District Court, Judge Rudolph Contreras, ultimately ruled against the government. He agreed that IEPA grants the president no authority to modify the harmonized tariff schedule via tariffs, and crucially, he denied the government's motion to transfer the case to the CIT, aligning with NCLA's core jurisdictional argument in substance.
So we saw different outcomes on the venue question between the DC District Court and the Florida District Court CIT.
We did, which highlighted the potential for a circuit split on the interpretation of IEEPA and the proper court to hear such challenges. NCLA's amicus role in learning resources shows their strategy of reinforcing their core arguments across related cases and their keen focus on procedural and jurisdictional battles that can significantly shape the legal outcome.
Let's do another quick micro recap NCLA's major legal battles, specifically targeting those IEEPA tariffs.
Okay. We've summarized NCLA's core legal arguments in cases like Simplified v. Trump and their amicus role in Learning Resources v. Trump, that IEEPA provides no statutory authority for tariffs, that using it this way constitutes an unconstitutional delegation, non-delegation, and that such significant actions trigger the major questions doctrine, requiring clearer authorization.
And we highlighted their significant battle over the appropriate venue for these challenges, arguing they belong in generalist district courts, not the specialized CIT.
Noting that while the simplified case was transferred to the CIT, the DC District Court in Learning Resources sided with NCLA on the venue issue and ruled against the government on the merits of the IEEPA tariff authority.
Now, NCLA's efforts extend beyond direct tariff challenges, right? They take on the powers of various agencies whose actions impact commerce more broadly.
A very significant example of this is the case AMG Capital Management LLC v. FTC. While this case wasn't about international trade tariffs, it directly challenged the enforcement authority of the Federal Trade Commission, an agency whose actions deeply impact domestic and international commerce and business practices.
The FTC. Okay, what specific power of the FTC was challenged here?
NCLA filed an amicus curiae brief at the Supreme Court challenging a long-standing practice by the FTC, using Section 13B of the FTC Act, to seek equitable monetary relief, things like restitution, paying victims back, or disgorgement, giving up ill-gotten gains.
Okay, getting money back. What was NCLA's argument against this FTC practice? Why was it wrong?
They argued that the plain language of Section 13B of the FTC Act only authorized the agency to seek injunctions, court orders, to stop illegal behavior in the future.
Only stop future harm, not get money back for past harm.
Right. NCLA contended that the FTC had unlawfully expanded its interpretation of this section over many decades to seek monetary remedies, in part because seeking monetary penalties or relief under other sections of the FTC Act involved more stringent due process protections and procedural requirements. NCLA characterized the FTC's reliance on Section 13B for money as a stealthy litigation strategy.
And what was the Supreme Court's decision in this case? Do you agree?
In April 2021, the Supreme Court issued a unanimous 9-0 decision agreeing with the position NCLA had advocated. The court held that Section 13B of the FTC Act does not authorize the FTC to seek or a court to award equitable monetary relief like restitution or disgorgement.
Wow, unanimous. A major victory aligning with NCLA's arguments then.
It's absolutely landmark. This decision dramatically curtailed a key enforcement tool the FTC had used routinely for decades to recover money for consumers or obtain ill-gotten gains in cases ranging from consumer fraud to anti-competitive practices.
What's the broader impact?
Its impact extends beyond the FTC, signaling a more exacting judicial approach to interpreting the scope of agency statutory authority, particularly when agencies seek monetary remedies. This precedent encourages courts to require clearer, more explicit grants of power from Congress for agencies to pursue such remedies and potentially affects other federal agencies that may have relied on similarly expansive interpretations of their statutes.
Right. The key takeaway from AMG Capital v. FTC is that the Supreme Court unanimously agreed with NCLA's argument that the FTC exceeded its statutory authority in seeking monetary relief under Section 13B, resulting in a major curtailment of a key FTC enforcement power.
Another case that shows NCLA's broader focus on challenging agency power beyond traditional trade bodies is RCALF USA v. USDA. This case concerns a rule mandating electronic identification tags for cattle.
Ah, yes, the cattle ear tags. And RCALF USA is an organization that has strong views on international trade issues related to beef, right? So there's a trade connection.
They do. RCALF USA, which stands for Ranchers Cattlemen Action Legal Fund, is an organization with strong advocacy positions on trade, including opposing certain international trade agreements and strongly favoring things like mandatory country of origin labeling, MCOL, for beef.
Okay.
So while the case is about a domestic agricultural regulation, it's deeply connected to broader commerce and trade issues for the cattle industry. NCLA represents RCALF USA and other livestock producers in challenging a rule from the U.S. Department of Agriculture, USDA, and its Animal and Plant Health Inspection Service, APHI, that mandates electronic identification EID ear tags for cattle and bison when they cross state lines, replacing older forms of identification.
What are NCLA's main arguments against this mandatory EID rule? What's their case?
Against the formal 2024 rule, NCLA has made several arguments. They contend the USDA exceeded its statutory authority because the underlying law authorizing animal identification doesn't specifically contemplate or authorize mandatory EID tags.
Okay, authority again.
They also argue the rule is arbitrary and capricious under the APA, asserting that mandatory EID is not truly necessary for disease tracing, which is a requirement in the authorizing statute, citing issues like lack of infrastructure, potential higher error rates, and an unfeasible compliance timeline for ranchers.
Practical problems, too.
Furthermore, they argue USDA lacks authority to impose administrative penalties for violations of the regulation, as the statute only provides for criminal penalties for violating the statute itself, not rules made under it. Finally, they claim the rule violates the Regulatory Flexibility Act by failing to adequately analyze the significant economic impact it would have on small entities like independent ranchers.
And NCLA also challenged an earlier, less formal version of this policy. They were fighting this before the rule.
Yes. Back in 2020, USDA had issued informal fact sheet guidance encouraging the use of EID tags. NCLA challenged this guidance, arguing it was effectively a rule disguised as guidance, and that the advisory bodies USDA relied on to develop it violated procedural requirements under the Federal Advisory Committee Act, or FACA.
What happened with that earlier challenge? Did they win?
A district court initially ruled against NCLA on the FACA argument. However, when NCLA appealed that ruling, the USDA chose to withdraw the contested fact sheet guidance document altogether.
Oh, so USDA backed down.
NCLA viewed this as a success, as it meant producers were no longer subject to the informal mandate, even though the court case itself became moot. Although the Supreme Court later denied review on NCLA's specific FACA interpretation argument, the challenge to the formalized 2024 mandatory EID rule is currently active litigation. It's seen as a key test of agency authority, especially in light of the Supreme Court's post-Loper-Bright jurisprudence, signaling less judicial deference to agency interpretations.
This case really shows NCLA's strategy of persistent challenge across different stages of agency action, from guidance to rule.
It truly does. It's a microcosm of NCLA's approach to combating perceived agency overreach at multiple levels, from challenging informal guidance to litigating against formal rules. It demonstrates their commitment to holding agencies accountable to strict procedural and substantive legal standards throughout the entire life cycle of policymaking, connecting domestic regulations to broader issues of commerce and agency power.
Okay. The key takeaway from the RCALF USA v. USDA case is that NCLA actively challenges agency actions beyond direct tariffs, scrutinizing the agency's statutory authority and adherence to APA procedures for rules impacting commerce, and has shown persistence in challenging agency actions from informal guidance to formal rules.
So let's bring together what we've seen of NCLA's impact in these landmark cases for a final mega recap of this section.
Good plan. We've covered their major battles against the IEEPA tariffs in cases like Simplified and through their amicus brief in Learning Resources, where they challenged the executive's authority to impose those tariffs using emergency powers and fought significant jurisdictional battles.
And we looked at their significant cases beyond direct tariffs, specifically the AMG Capital v. FTC case, which resulted in that landmark unanimous Supreme Court decision limiting the FTC's power to seek monetary relief.
A huge win for them.
And the RCLF USA v. USDA case, which exemplifies their ongoing challenges to agency authority and procedure in domestic regulation impacting commerce.
These cases demonstrate NCLA's broad scope in challenging agencies beyond traditional trade bodies and their strategic deployment of constitutional and administrative law arguments.
Let's summarize some flashcard facts about NCLA's impact.
AMG Capital v. FTC.
SCOTUS unanimously ruled FTC lacked statutory authority for monetary relief under Section 13. Big impact.
RCALF USA v. USDA.
NCLA challenges mandatory EID ear tag rule. Authority APA RFA. USDA withdrew earlier guidance after NCLA AI pouch. Ongoing fight.
NCLA scope.
Challenges agencies beyond traditional trade bodies. FTC, USDA. Focusing on constitutional procedural limits.
Finally, let's assess the overall impact of these judicial interventions and the rise of legal challengers like NCLA and look at what this means for trade and governance going forward. What's the bigger picture?
Well, NCLA's litigation efforts had a clear aim to reshape the legal landscape governing administrative agencies. By consistently raising and litigating arguments based on doctrines like non-delegation and major questions, and directly challenging long-standing deference, they seek to curtail agency power and enhance the judiciary's oversight role.
The AMG Capital victory is a prime example of successfully shaping precedent, right? A tangible win.
It is. It limited a key enforcement tool for the FTC and established a precedent for courts to take a stricter, more textualist approach to interpreting agencies' remedial powers. Ongoing cases, like the IEEPA tariff challenges, also have the potential to set major precedents on the boundaries of presidential emergency powers and how doctrines limiting agency authority apply to executive actions. Their goal isn't just winning individual cases, but influencing the fundamental legal principles that govern federal power.
Is there also an effect on agencies even when NCLA doesn't win outright? A kind of chilling effect. Does it make agencies hesitate?
So as to suggest that the sustained pressure from NCLA and allied organizations might have that effect, yeah. Agencies could become more cautious when contemplating ambitious regulations, especially in areas where their authority is potentially contested or the economic impacts are significant.
Just the cost of fighting.
The resources required to defend against these complex lawsuits and the potential reputational damage from losses like AMG Capital can prompt agencies to be more conservative or choose less aggressive policy approaches. So even without constant court victories, this litigation indirectly influences the regulatory environment.
What are the direct implications for federal agency authority, specifically in trade matters? How does this hit trade policy?
Successful challenges directly limit the tools available to the executive branch and agencies. AMG Capital removed a key FTC tool potentially used in commerce cases. Success in the IEEPA challenges would significantly constrain the president's ability to impose unilateral import taxes outside of the specific trade statutes passed by Congress.
And other cases?
Furthermore, cases like RCAL USA push agencies to be more rigorous, transparent, and better justified in their decision-making, particularly concerning economic impacts and the clear statutory basis for their rules. This can lead to more constrained and carefully justified behavior by agencies involved in trade and economic regulation.
And the challenge to judicial deference, especially after the overruling of Chevron, seems absolutely pivotal here. That changes everything.
It is foundational. NCLA's long-standing opposition to deference, culminating in the environment leading to Chevron being overturned, empowers the judiciary as a more assertive check. With Chevron gone, courts will conduct more independent review of agency interpretations.
So judges decide more.
This transfers significant interpretive power from agencies to judges. Judges will become more significant arbiters of what trade statutes mean, rather than deferring to the agency's reasonable reading in ambiguous areas.
NCLA frames their work as a defense of civil liberties, right? That's their core message.
Yes, they explicitly connect their administrative law arguments to the defense of what they see as constitutional freedoms, including property rights and economic liberties, against what they term an overreaching administrative state. Their broader ideological perspective, including skepticism of expansive federal spending and taxation, indicates that their interventions in trade and regulation are part of a larger vision for a significantly reduced role for the federal government in the economy and individuals' lives.
So their impact extends beyond just the technical details of trade law into bigger debates about government.
Absolutely. Their litigation and advocacy contribute significantly to a broader national debate about the appropriate size and scope of government, the inherent tension between regulation and individual liberties, and the judiciary's proper role in mediating these conflicts.
But does this create instability?
Well, while organizations like NCLA aim to bring more constitutional certainty, their aggressive challenges to long-established legal interpretations and practices could also lead to increased policy volatility and uncertainty, at least in the short to medium term.
Like questioning the use of IEEPA for tariffs, suddenly pulling the rug out.
Exactly. If fundamental assumptions about agency powers are successfully challenged and potentially overturned, it creates immediate uncertainty for businesses and policymakers about how future issues will be addressed. This potential for disruption highlights the transformative nature of these efforts to reshape core features of administrative governance. It's a bit like tectonic plates shifting. Even if the final landscape might be more stable from their perspective, the process of getting there involves significant unsettling movement.
What does the future hold for these kinds of legal challenges? Will we see more?
they are very likely to continue and probably intensify. This is especially true if the judiciary, particularly the Supreme Court, remains receptive to arguments focused on limiting government power, reinforcing the separation of powers, and imposing stricter constitutional constraints on agencies.
They have a long-term goal.
The sustained efforts to revive doctrines like non-delegation signal a long-term strategic vision being pursued through the courts. Success in these areas could profoundly influence not just judicial doctrine, but also how Congress legislates, potentially forcing greater specificity in its delegations, and how the executive branch formulates policy.
It sounds like the judiciary is increasingly being positioned as the central arbiter in these debates about government power.
That's precisely it. The strategic focus on judicial intervention positions the judiciary, and especially the Supreme Court, as the primary forum for resolving fundamental questions about the nature and limits of modern American governance. By seeking structural changes through judicial interpretation, these groups see the courts as perhaps the most effective means to realize their vision of a significantly constrained administrative state.
And there's a dynamic interplay with judicial appointments here too, I imagine.
Absolutely. As court victories advance the legal theories championed by groups like NCLA, it can elevate the prominence of these theories and the judges who embrace them. This increases the likelihood of judges with similar judicial philosophies being appointed to federal courts, reinforcing a feedback loop that could accelerate the reshaping of administrative law for years to come.
The role of these legal nonprofits challenging federal actions, including trade actions, is clearly a significant and growing factor in the fundamental debate over the future of American administrative governance.
It is. It's a fascinating battle playing out in courtrooms, affecting far more than just tariffs. It affects the whole system.
Okay, let's try to synthesize this whole deep dive. It's shown us that federal courts have taken on a surprisingly significant role in shaping U.S. trade policy, acting not just as reviewers, but increasingly as active referees and guardians of constitutional and statutory limits amidst trade disputes and executive actions.
Yeah, a much bigger role than maybe people realize.
We've seen a complex pattern of deference in some cases, like early Section 232, clear lines drawn in others like IEEPA, and the profound impact of challenges brought by groups like NCLA, culminating in seismic shifts like the overturning of Chevron deference.
Understanding this judicial dimension is absolutely crucial because these legal battles aren't abstract. They affect the cost of goods you buy, the industries that employ people you know, from solar power to agriculture to technology and steel, and most fundamentally, the balance of power within your government.
Right. Being well informed about this intersection of law and commerce is essential to understanding not just global trade, but the very structure of domestic governance today.
Absolutely.
So here's a final provocative thought for you to consider, building on everything we've explored today. Given that the judiciary is now more assertively interpreting the limits of executive and agency power in trade, especially in this new post-Chevron world where the expectation of deference is gone and courts are tasked with finding the best interpretation of statutes. If you were a policymaker crafting a significant trade action today, perhaps a major new tariff or a broad import restriction, how would you have to change your approach, knowing that your policy could very well face a constitutional or statutory veto in court? How will Congress respond to this shift, potentially needing to be far more specific in the powers it grants? And how will future presidents operate when faced with a judiciary that is, in effect, taking back the map from the agencies and drawing much clearer lines on the boundaries of their delegated power? This isn't just legal theory, it will reshape how America engages with the world economy for years to come.
It's a question that goes right to the heart of who decides what in American government. And the outcomes of the ongoing legal battles, well, they will provide the answers.
The Chevron deference once gave agencies room to stretch. That room is gone. From now on, vague laws don't invite creativity, they invite litigation. End Series 1.
Please like and subscribe.